consultations, discussions that resulted in this declaration, we have now finally the output of that process. And we got together an amazing panel of experts to talk about the output of that process. Now, there's a lot of background to the declaration. It's not the first time there's a declaration about the European Convention on Human Rights. There have been others before with varying degrees of impact and influence on the role of the court. The declaration does affirm commitment to the Convention as a really important institution in Europe. It affirms commitment to the role of the court and its independence. But at the same time, it is a document, a declaration that tries to influence the way in which the court interprets the Convention. And as you probably know all here, the way in which it tries to have this influence, or the area in which it tries to have more influence, is the issue of immigration control and how that's exercised compatibly with human rights. You don't wait for me to say that immigration is one of the most important issues politically in Europe and across the world. And naturally, the way in which the court, like the European Court, interprets the Convention has an impact on the ability and degree to which states can control immigration. So it's a hugely important issue. And we're going to explore the implications of the declaration, the way in which it came about, the attempt to influence the role of the court, and hopefully we'll get a better sense of its importance and significance. So I'm going to begin by introducing the panelists for today. So starting from my left, we have Natasha Mavronikola, who is a professor of human rights law at the University of Birmingham. She's also, if I may say, because we're very proud of that, alumna of the UCL Faculty of Laws. So it's great to welcome you back to your alma mater, Natasha. Next to Natasha is Rob Linham, OBE. He is Deputy Director for Rights and Public Law in the Ministry of Justice. And I'm delighted that he was able to join us because he has an inside perspective. He was involved not only with the declaration on the part of the UK government, but he's been a specialist on human rights as a civil servant for over 20 years. He was previously Deputy Permanent Representative to the Council of Europe and has represented the UK at the UN and the European Union. Equally importantly, he was also involved in the previous declaration, the Brighton Declaration, and it feels like yesterday when we're discussing the impact of that declaration, which now it's over 10 years ago, and we have another one now, and one in between. So we're very happy to welcome him at UCL. And on my far left is Mikael Rask Madsen, who is Professor of Human Rights at the University of Copenhagen. He's director there of one of the most important centers for human rights in Europe, the ECHR Center of Excellence there. And he's, of course, an expert in the ECHR and various reforms of the system. And on my right, my dear co-director, fellow co-director of the Institute, Veronica Fikvak, who is Professor of Human Rights International Law here at UCL, also an extremely eminent expert on the European Court of Human Rights, and someone who has written extensively on the ECHR. So have a mix of academics and civil servants, all of whom know very well both the Convention and the political background to this declaration. So without further ado, just also to mention that this is being streamed live. We're going to take questions from people here in the room. We might try to get some questions online as well. We'll see how that goes. It's not easy to do both. So each panelist will have 12 to 15 minutes. So we're going to go about around 7 o'clock, 7:15, and then we'll have about 15, 20 minutes for discussion. So I'd like now to give the floor to Rob. Rob, the floor is yours. You go first.
Thank you very much. Whenever I'm introduced as the sort of the civil servant who has done all of this on a panel of actual academic experts, you always feel like a right imposter. Here we go. One of the great curiosities of the ECHR is that it has no conference of the states parties, at least not as commonly understood. It is, I suppose, the Committee of Ministers of the Council of Europe, if you like. But therefore, when there is a desire, perhaps, for a discussion to take place for states to express an opinion on the scope of the obligations that they have accepted, and they are undoubtedly wide-ranging obligations, as well as the manner in which those obligations are policed or overseen. That often expresses itself as a moment of controversy, maybe even it looks like a moment of crisis. Now, I've actually, for my sins, been involved in 6 political declarations on the ECHR. There was the ones adopted at Interlaken and Izmir, 2010, 2011, the one adopted in my dear home city of Brighton in 2012, then subsequently at Brussels and Copenhagen, and now at Chişinǎu. You'll notice we're going conveniently in letter pairs there, so place your bets where the 7th will be. Those declarations all have 3 things in common. The first is they were all extraordinary events. And I use the word extraordinary there in the procedural sense of the word. In other words, they weren't part of the normal business of the Council of Europe as had been foreseen. They were, though, properly brought through its normal organs. The second is that they were all expressions of a moment in time. They were true as of the day they were adopted, and as of that day only, and at once had both a substantial effect and were also entirely of themselves ineffective. And I'll come back to that in a minute. And third, with all of those declarations, including the current one, the prophets of doom claimed that every single one presaged the imminent death of the convention and the destruction of human rights. Every single time. You said the Brighton Declaration. It's the one I probably know best. It was the one that was in our chairmanship, as it then was, in 2012. Let's take that as an instructive example. On that last point first, those who opposed it claimed to be protecting the court and decried its discussion of working methods and subsidiarity as an intolerable interference with the court's independence. The court itself now reports statistically on what it calls the Brighton backlog as set out in the terms of that declaration. The court also did not do everything the states proposed at Brighton. That was fine, but it was more than capable of looking after itself in that process. But if you ask what the jurisprudential effect was of the Brighton Declaration, then that's actually quite hard to pin down in isolation. Because you can't see these declarations in isolation. They're once both a product of the process that leads up to them, and they are an inspiration to and a guide to and an instigator of the process and events that follow them. And if you don't see them in the context of that arc, and you just look at the words on those 7 pages, you mislead yourself entirely. With the Brighton Declaration, it followed a process of consideration of the role of the court, of the appropriate limits of its functioning and a manner in which it should go about exercising its remit. But the Declaration in turn, of course, produced protocols 15 and 16 to the convention, which I had the privilege of chairing the drafting of those. But to anyone who's read, say, the analysis set forth by a certain Robert Sparno around not long after the Brighton Declaration, calling it the age of subsidiarity, it was very clear that the court had got there long before the ink had even been set to the page of the Brighton Declaration, let alone before that ink had dried. And that was precisely because the court is in that constant dialogue. It was hearing what was being said in that run-up process. It was aware of the discussion, the dialogue around it. It was not the declaration that started subsidiarity. One of the questions I'm therefore asked to consider tonight is the likely effect of the Chişinǎu Declaration. And my answer is therefore going to be the same. It's a point in time. It's an expression of states' opinions on the topics it covers, which is fairly specific on this occasion. But it is both part of and a product of an ongoing process that will have far more impact than, again, those, I think it is 7 or 8 pages this time. Should check I've got a copy at hand here. In particular, on this occasion, it's worth recalling that it's one point only of Secretary General Berset's 4-point plan. That this one document sits in the context of wider multilateral work to address questions arising from, challenges arising from, if you want to frame it that way, how you address migration in Europe. It's calling for things like multilateral work on model returns agreements. It's calling for things like work on tackling people smuggling and human trafficking across the continent. Things that the Council of Europe in its practical role is very well placed and in a lot of cases already does focus on, not even is well placed to, it does focus on them. So let me talk a little bit about the process, therefore, that got us here. The trigger for this one, as has been noted very widely, was again something of a moment of crisis. It was a letter written by 9 EU member states, originating very much out of a grouping that was brought together to discuss the process of migration law within the EU. And 9 states put their names to a letter that was, I think we would say, a pretty vigorous assault on the court and its jurisprudence. It was also, though, much more concerningly, an open letter, something that was taken outside the processes of the Council of Europe, that was addressed, as the Secretary General would frequently point out, to the world at large. Indeed, something that didn't even manage to mention the Council of Europe in any of its 3 pages. It managed to mention NATO, fascinatingly, but not the Council of Europe. What followed from that was a period of conniption, for want of a better word, a period of consternation. What happened, though, and what the right approach was then to bring this back into the processes of the Council of Europe. If you really want to look for threats to the system, that big threat there was taking it outside the process. And as you heard from my previous boss, Shabana Mahmood, when she was Lord Chancellor, she went to Strasbourg in June last year and was very clear that the follow-up to this should take place, the speech is published, should take place within the Council of Europe. The response to that was Berset's 4-point plan and calling for the Conference of Justice Ministers that happened last December. What that conference gave us was 2 things. It first gave us a roadmap, it gave us a process. Again, back within the organs of the Council of Europe, it entrusted to my old committee, the Steering Committee for Human Rights, prepare elements in the wonderful Strasbourg terminology for the declaration. What it also gave us, though, was an early expression of some of the states' views in the form of a side statement to which 27 states, including the United Kingdom, put their names, giving their view of some of the objectives to be achieved from the process. What is notable about those objectives is also how they grew. And a lot of these processes have a habit of starting from a single irritant, a single one subject that somebody wants to go after. In this case, it was very much articulate in the context of the deportation of what we call foreign national offenders in the United Kingdom, foreign criminals. But then it grew. Other people said, oh, well, while we're here, we should look at this, we should look at that. It expanded from Article 8 to Article 3, one my government was very interested in. It gained questions around things like mass migration. It gained questions around the so-called instrumentalization of migration, a word that will score you quite a lot in Scrabble, I believe. Yeah. So what you have here is an incremental process that sort of, as it rolls along, it gathers more and more elements. Now, one of the challenges with that, of course, is actually stopping it gathering so many elements that you can actually get it finished. The work in the CDH was therefore a work that was both forensic analysis, trying to work out what we were talking about, trying to work out what the issues were. I was sent back to my old committee, by the way, which is why I'm saying the word we. I was given an instruction very firmly by my bosses to go to achieve consensus, because that, again, the great risk to the system if the system couldn't respond. But it was forensic analysis. It was looking at the case law of the court that applied. It was trying to work out how this related to the European Convention on Human Rights. Not always clearest in all of the analyses put forward in the public domain, shall we say, as the link between the issue and the challenge and the ECHR itself. And it was working out then how to express what the states wanted to say about it. We must have done a fairly good job, because what we produced in that report, which is a public report, it was produced in March of this year, is basically word for word what was then the ambassadors adopted in the Committee of Ministers and what the foreign ministers agreed at Chişinǎu. Somebody was asking me before we started, was I at Chişinǎu, was I there to finish the job? Well, no, I was actually at a music festival when it happened, because the job was well and truly done by that point. In fact, compared to all of the previous declarations, this one was actually the smoothest. This was the one that was actually done the earliest. The Brighton Declaration, by contrast, we opened the Brighton Conference on a Thursday morning. It was finally agreed in Strasbourg on the Tuesday before that. So this one, with that sort of lead time, by far the smoothest process we've had. Let's talk briefly just about how the declaration is framed, though, because it's a very careful document, like all of its predecessors. It is not addressed to the court. It's in fact addressed to nobody. It is addressed to the wind, and that is by design. Because like all of those previous declarations, the states just speak forth their opinions. The wind may catch them and it may carry them across the Avenue de l'Europe, and it may blow past the court, and the court may choose to hear or not, it may choose to act upon them or not. But by not addressing it to the court, you leave the court the discretion whether or not even to hear them. If you do the opposite and address it to the court, you put the court in an impossible position. It either does what the states are saying and will be attacked for kowtowing to the states that have created it, or it doesn't do it, and there will then be a degree of political crisis that follows. By adopting that careful process of speaking to the wind and leaving the court in its discretion and its wisdom to do with that as it will, and it is, though, after all, an expression of the European consensus, much though I know you love that phrase, George. I checked. But it gives the court that autonomy. I remind you, with the Brighton Declaration, not everything the states proposed the court did, and that was fine. So I want to briefly then just touch on 3 challenges in it, and then finally emphasize 2 things this isn't. First off, the challenges. You also have to see the Chişinǎu Declaration in the context of about the last 17 years, the Interlaken process and what has followed. It is true that the Chişinǎu Declaration, in contrast to those 5 previous declarations, engages much more with the substantive case law of the court, rather than its procedural elements or its general jurisprudential theory, like subsidiarity and the margin of appreciation. But it is also a product of an evolution of the court, because through all of those declarations, there has been an increasing call for the court to become a court of wider adjudication, not a court merely of processing. It's a court that in the modern age, with the backlog that peaked at over 160,000, cannot be merely a court of processing. One of the whole points of the emphasis on subsidiarity was that it should be for national systems to fulfill their responsibility, shared responsibility, indeed, in the language, I think, of the Copenhagen Declaration. But what that therefore means is there is increasingly this jurisprudential dialogue between the Strasbourg court and the national courts. And in that, you have a Strasbourg court that is having to become comfortable with the role it has to play in that. Now, the Strasbourg court, if you ask, is it a civil law court or a common law court, the answer is in many ways neither. But of course, a lot of what we are describing here is very much a common law concept of precedent that was not an early part of the court's creation, that is still very much alien to a lot of the legal systems that take part in it. But nonetheless, that precedent is what is flowing into the national legal systems when those national courts and national authorities are asked to give effect to the judgments of the court. And so one of the big themes that comes through this declaration is saying to the court, please be cognizant that that is now your role. Whether you're comfortable with that or not, you are becoming of a manner of an apex court. And you need to be aware what you are saying to those courts that are trying to follow. How you are giving them a scheme of laws, a code of laws, a jurisprudential framework for them to follow, how you are aware of the contradictions and the clarity within that. The second challenge within this is one I've intimated already, that it talked about substantive law. That was somewhere where we had to be very careful. And in particular, the third challenge was that some of the topics we were talking about were live before the court. Instrumentalization in particular is the one where there is a judgment pending from the Grand Chamber. And so great care was taken, whether we succeeded or not, others can judge, but great care was taken to be in the way that was framed to make sure that it did not place the court in a difficult position with that final judgment. So what didn't this do? It didn't change the convention. It didn't tell the court what to do. To a certain extent, it didn't do much. It set forth a point in time. What it will do, though, is it will set forth a view of the states that will undoubtedly, like all its predecessors, be a point of reference in future litigation before the court, There will be a point of reference as the convention is taken into national systems that will provoke follow-up activities. Even the declaration itself refers to work, for example, on how you produce better asylum decision-making and draw together the lessons that states have across Europe on that subject. But what you have in the declaration more than anything else is a defense of multilateralism. Because in the end, something that started in a process of the world at large, finished back in the organs of the Council of Europe, finished where it should be, and hopefully has lowered the temperature somewhat by doing so. I'll stop there. Thank you.
Thank you, Rob. Thank you for this really, really interesting perspective, which I interpret to be optimistic of sorts. And I really welcome that. I mean, it is those of us who spent so many years reflecting on the convention and the court. We are well aware of this really dual character of the court. On one hand, it's based on something really robust, which is it's a legal institution, it's a court, it's a binding document. But on the other hand, it ultimately has something very fragile, which is the political will of the states. So that dual nature of the whole system is always there, and how you navigate between the two is really difficult. And what you described seems like a very good way of navigating, at least in a particular time slot. But I take away the moment in time that I think was key to your approach. So thank you for that. I'm going to go now to Natasha Mavronikola, and it's interesting as Rob mentioned that, of course, many of the issues that initially led states to writing letters was, as I mentioned, the issue of immigration, and human rights lawyer will know that this is handled primarily through Article 3. So the prohibition of inhuman and degrading treatment, which by the terms of the convention is an absolute right, and a lot of the satisfaction of not only governments, but a lot of the public as well stems from the fact that this is seen to be tying the hands of governments when they control immigration, deal with refugees and asylum seekers. And we couldn't have a better expert on Article 3 than Natasha Mavronikola, because it's written extensively on that article of the convention and how best to understand and interpret it. So I'm really looking forward to hear what she has to say about the impact of the declaration on Article 3.
Thank you so much. Thank you, Veronica, for bringing us together for this very timely conversation. Thank you, George, for welcoming me back. And I should mention that probably, the seeds for my Article 3 obsession were planted, perhaps even in this room, for better or worse. It's a delight to be here as perhaps one of the designated prophets of doom. But I take my role to be more of an expository rather than prophetic one here, just to illuminate what I see as some key facets of the Chişinǎu Declaration in relation to Article 3, and leave a lot for you to judge, although perhaps you will gather my feelings about them as I discuss them. So I will consider three aspects of the Chişinǎu Declaration. First, its approach to the absolute character of the prohibition of torture and of inhuman or degrading treatment or punishment under Article 3 of the ECHR. Second, its insistence on what I refer to as an Article 3 minimalism. And finally, its relationship to the politics of othering. Now, I'll begin by reminding or reiterating to everyone that the Chişinǎu Declaration seeds were planted at least a year ago on the 22nd of May of 2025 with the letter of 9 that Rob mentioned. A letter issued by 9 member states of the Council of Europe and of the EU, claiming that an overreach in the application of the ECHR had, and I quote, resulted in the protection of the wrong people, and I quote, posed too many limitations on states' ability to decide whom to expel from their territories. This was followed up by the statement from 27 states in December of 2025, in which these 27 states asserted, quote, the rights and freedoms of our populations, and signaled that, I quote, a right balance has to be found between the migrants' individual rights and interests and the weighty public interests of defending freedom and security in our societies. These interventions, which preceded the consensus adoption of the Chişinǎu Declaration, form an important backdrop to how we must approach and understand the declaration. So let me begin by considering how absoluteness is addressed in the declaration. The declaration starts by stating that, quote, it must be emphasized that the prohibition of torture and inhuman or degrading treatment or punishment under Article 3 of the Convention is absolute. What does it mean to say that the prohibition under Article 3 is absolute? Well, as the text of the declaration itself highlights, it means that it permits no derogation at time of war or other public emergency threatening the life of the nation. It contains no inbuilt exceptions of the sort you find in paragraph 2 of, say, Article 8 or Article 10 of the ECHR, and it thereby allows for no legitimate interference. It should also be stressed that absoluteness also means unconditionality. The right's protection cannot be displaced or dented on the basis of the wrongful behavior or simply the unpopularity of its particular beneficiary in any given case. Of course, it's important that this absolute character is reflected in the interpretation of the relevant right. In particular, the prohibition of torture and inhuman or degrading treatment or punishment must be specified, as Alan Gilworth also argued, and as I also argued in my work on the subject, must be specified without reference to the consequences of fulfilling or violating that obligation, right, the prohibition. So in order to cohere with its absolute character, the interpretation of an absolute right must set a firm and not a porous red line, and it must not displace the right or parts of the right through the back door by reference to the consequences of fulfilling or violating the right, or by incorporating qualifications, conditions, or other mechanisms of displacement in the context of the right's interpretation. So how does the declaration proceed to potentially challenge or contradict the absolute prohibition in Article 3 of the ECHR? I think there are several ways in which the declaration undermines or takes aim at absoluteness. First, it does so by referring to the consequences of Article 3's reach in stipulating how Article 3 should be delineated. The declaration tells us that, and I'm quoting, the minimum level of severity of ill treatment that constitutes inhuman or degrading treatment or punishment must, ... remain high, ... avoiding unnecessary constraints on decisions to extradite or to expel foreign nationals. The declaration also highlights the need to avoid the quote-unquote impunity which may arise when Article 3 gets in the way of extraditing somebody to face criminal prosecution and punishment. I would suggest that the implication of these framings is that the opinion of these states at this point in time is that Article 3 should be delineated in such a way as to avoid unnecessary constraints on expulsion or extradition decisions or any impunity flowing therefrom. Furthermore, the declaration adopts balancing and relativist rhetoric that appears orientated, at least in part, towards diluting or restricting the non-refoulement obligation under Article 3. The declaration opens with a preamble making reference to a dictum from the 1989 judgment in Suring against the UK to the effect that, and I quote, inherent in the whole of the convention is a search for a fair balance between the demands of the general interest of the community and the requirements of the protection of the individual's fundamental rights. This is an overarching statement that appears to apply across the board, so in relation to Article 3 and Article 8, as they come up in the declaration, even though in case law that followed Suring and the UK, the notion of any sort of balancing of the non-refoulement obligation under Article 3 in particular was rejected. The declaration also stresses that norm appliers, including domestic courts that are applying Article 3 of the ECHR, must exercise caution in applying the delimitation of notions of torture or of inhuman or degrading treatment or punishment in the expulsion or extradition context, particularly when it comes to destination states, right, states where they're sending people off to that are not party to the European Convention on Human Rights. This is effectively a relativist stance that is saying that when it comes to the obligation not to send people off to places where they may face ill treatment, the sending state, which is bound by the European Convention on Human Rights and against which the relevant proceedings are being brought, should potentially be held to a looser Article 3 standard on the basis that the destination state is not bound by the ECHR. This brings us to the related issue of the Chişinǎu Declaration's push for minimalism in relation to Article 3. The declaration suggests that, and I quote, sorry, I'm quoting a lot, the absolute prohibition of inhuman or degrading treatment or punishment reflects that it relates to the most serious forms of ill treatment. And accordingly, it tells us that the minimum level of severity that delineates the applicability of Article 3 must be high. I've already mentioned this. Now, the implication of this is that Article 3 should capture a narrow rather than a wide range of conduct. And as we have already discussed, in doing so, in capturing a narrower set of conduct, it will avoid unnecessary constraints to states' migration practices. The gist of this argument of minimalism, this approach of minimalism to the scope of Article 3 is that because it is absolute, Article 3 should be narrow. This minimalist stance, seen in its best light, can be seen as being based on assuming that ill treatment as severe as that prescribed by Article 3 of the ECHR must necessarily be an aberration. It must be infrequent, it must be exceptional. But there is no empirical or reasoned basis for simply assuming or asserting this. On the contrary, a body of multidisciplinary insights and lived experiences on matters ranging from interrogational torture to police ill treatment and prison conditions to gender-based violence has shown us that inhuman and degrading treatment, as well as torture, can be pervasive as well as egregious. The more sinister basis for this minimalist stance is, of course, take us back to the unnecessary constraints point, that if the so-called Article 3 threshold represents a red line beyond which desired government action is deemed conclusively unlawful, it is preferable for states that the threshold be as high as possible. So what we could read between the lines, or not so much between the lines, is this. Given that absoluteness means that Article 3 can really get in our way, Article 3 must be interpreted so as not to get in our way too much. Indeed, the declaration seems to be signaling that Article 3 best not get too much in the way of, to quote from the declaration, new approaches to address and potentially deter irregular migration. Besides a minimalist approach to Article 3's substance, the declaration is built, I think, on a minimalist attitude towards Article 3 compliance. The Chişinǎu Declaration makes reference to uncertainty in the European Court of Human Rights Article 3 case law and asks the European Court of Human Rights for guidance or further guidance in respect of how Article 3 applies to a range of circumstances. Now, I do not dispute that there is a degree of uncertainty in some Article 3 case law, or indeed that guidance on the contours of absolutely prescribed conduct is worthwhile and indeed integral to the specification of an absolute right. However, it seems to me apparent from the declaration and the pronouncements that preceded the declaration that guidance is being sought not so as to minimize the circumstances in which people are subjected or exposed to Article 3 ill treatment, but so as to maximize desired state action that skirts the boundaries of Article 3. That this is so is illustrated further in the declaration's insistence on quote-unquote caution in applying the non-refoulement obligation under Article 3, because besides the relativism of this caution towards the application of the non-refoulement obligation, the minimalist approach to compliance emerges also in the application of caution, because here what we've got is not, to err on the side of caution here does not mean to err on the side of avoiding irreparable harm, but rather to err on the side of enabling desired state action, right? So you're erring on the side of caution in terms of erring on the side of enabling desired state action, not in a sort of precautionary principle sense, right, of avoiding irreparable harm. Finally, this minimalist stance, I think, is compounded by the declaration's incorporation of a much criticized dictum. I have to say that, much criticized, because I've criticized it as well. A much criticized dictum of the European Court of Human Rights to the effect that, quote, the court has rarely found that there would be a violation of Article 3 if an applicant were to be expelled or extradited to a state which had a long history of respect for democracy, human rights, and the rule of law. Now, while this statement appears descriptive, it is and has always been prescriptively orientated. It is implying that Article 3 should rarely be applied by relevant norm appliers to bar expulsion or extradition to such a lovely state. This adds to the stance of minimalist compliance and raises questions about how states might want presumptions of compliance and notions of safe countries to operate when it is clear from the court's case law that no country, whether it's in the EU, in the Council of Europe, or otherwise, can be deemed safe in a way that displaces the need for individualized assessment when an Article 3 issue has been raised. And the question of how a state can come to be characterized as having a long history of respect for democracy, human rights, and the rule of law is also an interesting question. The court first put forward this notion of a presumptively Article 3 compliant state in an extradition case in early 2012. And the state it was referring to was, drumroll, the United States of America. This was a dubious description of the United States in the application of Article 3, given that by 2012, it had become abundantly clear that the United States had been involved in a prolonged campaign of extraordinary rendition and torture in the aftermath of 9/11. So the Chişinǎu Declaration challenges absoluteness by invoking necessity, balancing, and relativism, and adopts a minimalist approach to Article 3's substantive scope and to Article 3 compliance. And what for? For what? So this brings me to my last point. I think the most generous reading that I can give to a lot of the mobilization around the Chişinǎu Declaration and the UK's involvement in it is that it has been pursued, at least by some actors, in the name of upholding and indeed preserving human rights. The message from some key actors, including key UK actors, is that we have to modernize the convention system in order to ensure its continued survival. But I think we have to ask what exactly is being preserved. The declaration shows a readiness to relativize the absolute prohibition of torture and inhuman or degrading treatment, a push to dilute, perhaps to oblivion, the Article 8 rights of certain groups of people in certain circumstances, an appeal to employ the living instrument doctrine to cut back on human rights protections, and an overarching rhetoric that appears to prioritize, to an extent, a broadly construed anti-migration public interest over migrants' human rights. So is what is being pursued ultimately a preservation of the Council of Europe system of human rights protection, or potentially a gradual but profound distortion of this system? More generally, and looking at the pragmatic politics of it all, I would say that it is seriously questionable whether absorbing and partly endorsing narratives that paint human rights as the problem and that cast some human rights holders as effectively unworthy or less worthy of human rights protections is the way to save human rights. At best, as Mark Elliott has highlighted, the Chişinǎu Declaration can be seen to epitomize an inclination to appeal to everyone while potentially ultimately pleasing no one. But it seems to me that far from just being this kind of compromise, the declaration and the process that led to it can also be seen as reflecting a certain normalization, mainstreaming, and actioning of anti-migrant narratives in a way that has the potential of helping to make the case for those that are against the human in human rights, and for political parties that are simply against human rights. I'll leave it there. Thank you.
Thank you, Natasha, for very carefully dissecting the declaration vis-a-vis its impact or its take on Article 3. I think very often people approach Article 3 in the non-refoulement as a technical issue in the case law, something that could have been otherwise, and the court took a wrong turn. Maybe he can roll back these decades of case law. But as you explained, it's not really just an approach of the court. It's part of the core notion of the right not to be treated as in a human and degrading way. And the idea that we can, tamper a little bit with the scope to achieve some benefits is hostile to the logic, not only of the right not to be treated in human and degrading treatment, but also human rights as such, the human and human rights. So thank you for that. It was really, really important to share. So now I'm going to go to our third speaker, Mikael Madsen, who, apart from being an expert, of course, in human rights in the ECHR, has also been involved with the Danish government, both for this declaration and other work of the Danish government. And Denmark was one of the countries that, was leading the opposition, so to speak, in the initial letter and subsequently. So I'm really looking forward to hear what his experience has been with respect to the declaration. So, Michael, the floor is yours.
Thank you very much. Can you hear me?
Yes.
Yeah. And thank you for inviting me here, Veronica and George. Let me just clarify, I have not been involved with the Danish government. I think it's important to say, both for their sake and my own. I have observed.
What I mean, yeah,
observed very closely.
That's what I meant.
Yeah. So what I'll say something about is the declarations in general, dating a little bit back, a little bit at the rock, and then focus in on the Chişinǎu Declaration a bit more. So as already said, the current declaration is clearly a declaration that builds on the legacy of some previous declarations, starting with the Interlaken one. It has most in common with the Izmir Declaration, the Brighton one, and the Copenhagen declarations, in the sense that it sets aim at the balance of power between the court and the member states. It also, particularly Brighton, Copenhagen, and Chişinǎu, share a similarity in the strategic approach employed by the instigators and negotiators of the declarations. And with Rob in the room, I have to be a little bit careful here. But I think it's fair to say that at all these processes and declarations, there was a particular negotiation strategy employed, which had originally been refined by the Foreign Office. The first step is basically you start out with a bit of a shock. You make a big splash. Before the Brighton meeting, you might remember there was a so-called leaked draft, which made suggestions for changes that went significantly further than what was eventually agreed upon by the member states, and certainly a lot further than what specialist academics and broader human rights movement would accept, the Dunes brothers. Before the Copenhagen summit, the same was done by simply making a draft declaration public, and a draft that undoubtedly would stir controversy. Before Chişinǎu, you had first what I refer to as the Meloni-Frederiksen letter, then the follow-up by the 27 member states, and in each case, the stated objectives went significantly further than was what was eventually agreed a week ago in Moldova. So what you can observe, and I think what diplomats will call it, is an onion strategy. You peel off a few layers after the initial shock and awe in order to bring the member states back together. And this particular, let me call it, art of the deal, to quote a famous American scholar, has been applied in all of these declarations with more or less elegance. Each time there has been considerable pushback from both governments and experts and human rights activists, and each time the end result has been a boiled-down version of the original proposal. But thereby consensus has been reached. Consensus in a particular sense that it's a document that everyone can live with. I think there's a fine distinction. So as to the difference, though, from Brighton to Copenhagen to Chişinǎu, Brighton very clearly resulted in amendments to the convention through additional protocol 15 and 16. Such an outcome was not envisaged in the Copenhagen Declaration, and the same is obviously true with the Chişinǎu Declaration. Both are declaratory, and that in a much more political sense than Brighton. And there I think you have the first and real difference between them. Chişinǎu, in my view at least, is probably best read as a sort of a collective political statement by Council of Europe member states executives through their diplomats and legal advisors, but not as a legal technical statement of precise change. It is a bit like Rob said, it's a statement of a position rather than a sort of an order of a precise change. It's of course not because the governments involved were not seeking change. The initiative originally for the Chişinǎu protocol or process was not Moldova, but rather, to be honest, Denmark, backed up by Italy, and then 7 more countries. There's also a little bit of a novelty in the way things went about it. And one of was that the problem the UK was facing before Brighton and Denmark before the Copenhagen Declaration was clearly that their proposals seemed out of sync with a general consensus in the Council of Europe. So for Chişinǎu, they went for some kind of consensus before detailing the proposals. And this was likely a lesson learned from previous processes, that you involved more earlier on in the process. Another lesson learned was that there was more space to make political statements about the future of the system than legal amendments of the actual convention. So in other words, you move into a different playing ground where there is more space and you can get away with more because it actually is less consequential immediately. You could argue that Chişinǎu is an innovation in the system in the sense that it solidifies a role for the political branch of the system. As you know from Brighton and Copenhagen, the claim made by the governments in each case was there had to be some kind of checks and balances in the system, a place where government could express their positions on developments in human rights. This is obviously a highly controversial issue, and it was debated much in the Copenhagen process in particular. In fact, if you read the Copenhagen Declaration very carefully, I don't think many people are doing that anymore, but you will find a place, something called the Kokkedal Dialogue, which was an attempt to devise a forum for such precise interaction to avoid that human rights discussion went ballistic each and every time. And for non-Danish readers, I can reveal that Kokkedal is a geographic location, a castle where the high-level seminars took place for the Copenhagen Declaration back in the day. So this is the more political and institutional dimension of the processes. There's obviously also a substantial one, namely the place of immigration politics and law in the convention system. And this is where it gets very complicated. As already stated by the previous speakers, Denmark was a bit obsessed with Article 8 in the context of expulsion of foreigners who have committed serious crime. The UK had at this point developed what some call an unhealthy obsession with Article 3 in the context of expulsion and transit hubs. Other states had a focus on mass arrivals, on the instrumentalization of migration, so it was a mixed bag, to say the least. It's also the reason that the final document can be read as a kind of attempt at formulating some common elements of a migration and human rights statement. It is, for the same reason, a bit of a hodgepodge of these different inputs, and the effect of the document will likely be very, very differentiated. To quote from a blog last week, I quote, "It contains a pick and mix of instructions to the court on how it should reduce the crime protections, relativize absolute provisions, and give states more leeway to what they wish in various contexts," end quote. You find it on Fasten Blog, highly recommended. It's written by Veronica.
And Michael.
And myself. The part of the story I know best is, of course, the Danish part. So Article 8's protections of family life in the context of expulsion cases and has been essentially a political saga for the more than 10 years, really 20 years. It was the precise same background that led to the initiatives of the Copenhagen Declaration. And while the Danish government in 2018 claimed that the issue had once and all been fixed, the Danish initiative in the context of the Chişinǎu process was triggered by the precise same political outcry. The basic issue we're facing is that the question has become a kind of race to the bottom, where practically all parties from the center into the right have engaged the question with more or less plausible legal solutions. This includes the governing Social Democrats, the Liberals, who have integrated tough stances on migration in their overall political repertoire, something that is looked much to from other political corners of Europe at the moment. But because of this political competition over being the toughest on migration, expectations have not only become unreasonable, but also pretty radical. Denmark, for example, has legislated in great detail on how to handle expulsion cases and included instructions that civil servants should go to, I quote, the limits of the conventions. That is the precise wording used in Danish. But even more radically, earlier this year, a new draft law was presented which directly refers to future changes in practice in Strasbourg through the Chişinǎu Declaration as the background for new, even more draconian rules on expulsion. So they're kind of picking the apples from sort of early spring rather than September. Here in this law, it suggested that any prison sentence of more than 1 year should automatically trigger expulsion. This is, by the way, the reason that in Article 8, I think it is, of the Chişinǎu Declaration, there's some strange wording about how the length of prison sentences reflect the seriousness of the crime. And that is because in Denmark and the rest of Scandinavia, they will claim that the length of prison sentences is shorter comparatively for serious crime than the rest of Europe. And therefore, expulsion is possible with just 1 year sentences in Denmark and Scandinavia. The bottom line is basically that the Danish government, by these domestic legislative initiatives, have put maximum pressure on the court. Right now, this law in question is put on hold as an election, at least temporarily, has stopped it. This is obviously one way already that the Chişinǎu Declaration might have effects. I do not by any means expect the court to rubber stamp the Danish law, but it undoubtedly puts pressure on the court. More generally, what are the effects of this declaration? I think what we can observe from the previous declaration is that political signaling of the declarations is where they have the greatest forms of impact, particularly that it's aligned with developments in the jurisprudence of the court. For instance, all the talk about subsidiarity in Interlaken and later in Brighton have impacted on the court long before the actual legal amendments were made. Actually, some research done by myself suggests that the biggest measurable effect of Brighton and Interlaken was by political signaling and not by changing the law. Actually, the moment you change the law, the effects were smaller than it was only political signaling. So to wrap it up, it is a political statement rather than a legal technical proposal, but we also know from studying this over the past 15 years that that political signaling is perhaps precisely where it has the biggest effect. Thank you.
Thank you very much for this. It is not a legally binding document, but it may have an impact on the way the law is being interpreted. I mean, I'm looking forward to the discussion after our finalists, but it's very interesting to me what you said about the innovation of this declaration is giving a forum for the political voice of the states as something which is new in this. And it'd be interesting to discuss why this came about, what function is performed when states can do this political theater, where they have a forum and they go out and say, you know, we want tougher, to be able to take tougher measures about immigration, for example. What is the role of this political theater, right? It's a forum for the governments. Who is the audience for this? And why is there a need for an audience for this? So yeah, great. So our fourth and final speaker is Veronica. Veronica, the floor is yours.
Thanks so much, George. And I wanted to thank all of our panelists for coming today and outlining the different positions, and especially to Rob for listening to three academics and push back. So I thought, I've worked with both of my colleagues on this since I think September 2025, and so I sort of. There's very little I can add because we've been working very closely, but I thought I'd make sort of three small points. And the first one is, I think this declaration, and we need to admit, it's a different kind of declaration. It is for the first time that actually two articles, substantive articles of the convention are mentioned, Article 3, Article 8. And on each one of these, the declaration goes into a good amount of detail about how the court should interpret these articles, specifically in circumstances of return of foreign criminals or in expulsion cases. Now, a number of people have said that actually when you read the text of the declaration, it is full of contradictions. So Natasha has already said that in relation to Article 3, it underlines the absoluteness of the provision, but then talks about a relative assessment of what amounts to inhuman and degrading treatment. The Commissioner for Human Rights has said that although it underlines the independence of the court, it's effectively telling the court of how to read the document. It's also impressively long. It is 7 pages long, and that is both Robert and Michael have said because a number of countries came to the equation, to the negotiating with a shopping list of what they wanted in that declaration, and most of these elements were included. But I think it is important to underline that maybe that's a good thing. And I want to say why that is a good thing. So we started with the letter of the 9, we then continued with the letter of the 27. during this process, the kind of underlying threat to the whole discussion was that there may be, at a certain point, a subsequent agreement, a protocol to the convention that would change specific articles of the convention, or that would agree something in addition. We haven't got there. So what these 7 pages of, I'll say, contradictions and repetitions say is that although there's a general agreement on migration, there is no uniform migration policy that would kind of bring Europe together. So what we have seen is there is no clear, brief, direct amendment of protocol to the convention. So that's sort of, I guess, one thing. And in contrast to the letter, and I think to the 2 letters, Rob said this already, the process was led by the Council of Europe, and that is reflected in the words of the declaration. I think specifically we have to underline that the words of the declaration are actually pulled out of the case law of the European Court of Human Rights. Now, it partly means that when states are expressing their view, they're using the words of the court. But I think there's a deeper point that's been missed in when we look at this copy pasting exercise, and that is that if we're using the words of the court has already made many of the steps that states speak of in this declaration. And that partly goes to what Michael was saying, that a lot of these steps have already been made, and the declaration in some sense codifies them. So if the walking back has already occurred, then the question is, what is the point of the declaration? Like, why do we need it? And this leads me to my second point. And that comes really from the conversations I've been having in the last 8 months about what is the aim of this declaration. And the kind of consistent message that I've been hearing is that the need for the declaration arises because of how domestic courts interpret the convention. Specifically in the UK, the concern was raised by one specific case where a Croatian precedent, a Croatian case about prison conditions was applied to a Brazilian situation, to Brazil prisons. And so a Council of Europe standard was applied outside of the Council of Europe. And the message was that the declaration would redress this error. I guess my inherent uneasiness with that idea is that is declaration an appropriate tool to speak to domestic courts? The declaration isn't addressed to domestic courts, right? It speaks to the wind, as Rob said. And before the domestic courts can apply a change in jurisprudence, we would need to have a case that would get to Strasbourg, that Strasbourg would decide. And we're talking about years before domestic courts could actually apply such a precedent. The other option I've heard in these discussions is that governments are going to use the declaration before domestic courts prior to a Strasbourg ruling, so that they're going to go into a court ruling to ask domestic courts to apply the convention, let's say, restrictively or on narrow grounds, just on the basis of the declaration. Now, barristers tell me, who've got more experience litigating these cases, tell me that there's an issue of whether domestic courts, domestic judges, let's say in England, will accept that. A declaration is a guideline. It's an interpretive, it's not a binding tool. It is addressed to the wind, not to the domestic courts. But there's an additional element, which is having done lots of talks in the last few months, I'm not sure the domestic judges are even aware of the existence of the declaration and of its relevance to the interpretation of the convention. And so the problem in some sense is that the declaration changes nothing at the domestic level, where most of migration decisions are made. What it requires in order to take effect domestically is really legislative action that would put the relevant elements of the declaration and how it should be used to interpret the convention, that should be put into domestic law. Now, Michael mentioned that only Denmark has thus far made such a proposal, and that's on hold whilst we wait for a new government. But the UK hasn't followed this up. And even though it has been pushing for Article 3 amendments, without additional legislation, the declaration is unlikely to have the domestic effect that has been pursued. So then this brings me to my third point. And I wonder a bit like Michael, whether the declaration is a communications exercise, really primarily aimed at a national internal audience, right? So it's speaking to a very specific electoral kind of population, both in Denmark, in UK, and Italy. And the message seems to be domestically that, I guess, Strasbourg has been tamed, the convention has been reformed and future-proofed, and the migration problem has been fixed. Now, in practice, this seems to be far from the case unless domestic action follows. But one problem that really exists is that we can't really expect the Strasbourg court for migration cases represent 1.5% of its work to resolve migration problems that states have at home. Now, this doesn't mean that the ECHR will not respond or kind of take into account this declaration. The declaration has a signaling effect on the court. There's a study that has just come out showing that the 2010 Izmir Declaration, which was also where the debate was on migration, that led to exponential and statistically significant decrease in the number of violations in migration cases under Article 3. Michael spoke about his own research, and his own research showed that after Brighton and Interlaken, the use of the concept of margin of appreciation shot up, and also the number of violations against all democracies, so countries that joined before 1990, decreased. So all of these leaves me with no doubt that the declaration will have a similar impact on the international level, and that this will happen, especially at a time when the court has already been taking steps back on migration. But I'm not sure it will have the bite that we expected at home, and that is still to be determined. So I'll stop there. Thank you.
It's really interesting that both Veronica and Michael, I think, emphasized that domestic audience is probably one of the primary recipients of the declaration. And it's interesting, I think, what I took away from your talk, Veronica, is that a lot of the states have been blaming the court for the difficulty dealing with migration. And now they think, well, if we do this declaration, we can tell the electorate, problem solved. It was the court's fault, and now the court is going to back down and problem fixed. But it's not quite that easy. Great. So before we open up the discussion, I'd like to ask the only non-academic on the panel if he would have any reaction to the three academic interventions. Not wanting to put you on the spot, but since you are really the only civil servant, how do you feel about the academic reception? So there are concerns about undermining the absolute character of Article 3. And there are concerns about the impact the declaration will have on the approach of the court down the line without necessarily making things any better domestically. So, any sense or anything you can say about what's been said?
Defend yourself, you say. Remove the daggers from your back and examine them one by one. The first thing I think I'll say, this is like more than anybody else. I think you think we're cleverer than we are. I think is what I would say. Well, you're very kind, or more cunning than we are, perhaps. Certainly, to suggest that to give you an answer, for example, on the Brighton Declaration and the leak of that happened from within the organs of the Council of Europe. In fact, I can tell you precisely which office, and I'll tell you afterwards that the Council of Europe leaked it. It was not us, and we certainly didn't want it leaked. So that idea that there was some sort of confected crisis in that way, that just, I'm afraid, suggests that we're far cleverer than we are. So, and I think, my response to Natasha again on some of those points, I need to go and think about some, because it's a dense analysis. What I would say on the absolute character article, firstly, as you know, the declaration is very clear about that absolute nature. I think the way it played out in the room was a discussion very much of ambit. And I think it is clear if you look at the case law of the court over, say, 20, 30 years, there has been a drifting of the ambit of Article 3. There's sometimes been, I think the clarity point comes in particularly when the question is, where is the line drawn that brings you within Article 3? I don't think anybody at any stage in any of this discussion was arguing that once you are within the ambit of Article 3, that there is any exception to, any confrontation to, any attempt to dilute that absoluteness. The question was that one very much of when are you within the ambit? The challenge of that, and when you quote the point about impunity, for example, that an absolute Article 3 prevents a person facing justice in the case of the Brazilian extraditions, you know, one person who was, well, I probably shouldn't be too specific about the cases, but certainly, you know, very serious and absolutely repugnant offences that we were talking about there, that will certainly be perceived at the world at large as impunity, because those people did not, as a matter of fact, face justice. And so, not necessarily from a jurisprudential point of view, but certainly from a philosophical point of view, you have to ask the question, well, where do you draw that line at which absoluteness kicks in? I think that the final reaction I would sort of make to all of this is that there's a lot in the declaration that is, you know, I think you picked it up, that it uses the court's words back to it. And that again is very deliberate, because a lot of this, you come to ask the question, Veronica, about sort of who's the audience. There is an element here of demonstrating what is not necessarily widely understood and actually citing those principles. I mean, it is, you know, we cite the principle that there is nothing in the convention that prevents states from adopting their own immigration laws. Of course, we all know that. Everybody in this room, I sincerely hope, knows that. But to have it on a piece of paper that can be then taken out to the world and go, look, you know, anyone who is telling you to the contrary, there it is in black and white on a piece of paper. Now do you believe this? And so to answer your question about sort of the audience and does it make it better or worse, one of the things we are grappling here is so much misinformation, even disinformation about the convention. Having some of these things reiterated in black and white means it becomes show, don't tell. So those would be just a few of my reactions to the daggers in my back.
Thank you. Thank you. Thanks very much for this, Rob. I guess the academics would still worry that those minded to make the prohibition less absolute are also likely to present this as an ambit issue. Not all of them, but it's very easy to, instead of saying, I don't think this right should be absolute, is to say, well, I think the ambit is narrow. I don't think there's any difference between the two. I think you can easily try to play with the ambit test as a way to introduce balancing. And I think that could be very dangerous. But you know, I take a point that, you know, we'll have to give meaning to the right, and once it's within the meaning, then it's absolute. But one can play fast and loose about what's in and what's out. And as Natasha said, there's a worry that this in the declaration is an invitation for the courts to do that, and that can normalize perhaps a more relativist approach to Article 3. But I take a point about that. No, it wasn't about the intention, but about how it's been interpreted. Yeah. Great. So I have two requests for our audience here, one more challenging than the other. The first request is to join us for a drink at the end of the event, which is in the place called The Hub, which is on the first floor. And it's a challenge to get there, but you can follow our dear colleague here. So that's going to take place 2 floors up. The second request I have is less challenging, but way more important, is to join me in thanking our speakers for today, for the wonderful interventions. And thank you so much.